Well, the simple answer is yes. There are several things at work here. If you file the bankruptcy and the property settlement has not yet been completed, the division of assets, that stayed by the automatic stay. And unless this stay is lifted, there is no continuing the division of assets, no property settlement. Another thing that comes up, and this is much more frequently after the divorce is completed and you file a bankruptcy, is something I just talked about a little bit ago, and that's the concept of fraudulent transfer. So you really have to be sure that there is an even distribution of the assets and an even distribution of the non-exempt assets in the property settlement. Because if there isn't, then if you're in a Chapter 7, the Chapter 7 trustee is going to seek to undo, the term is avoid, the fraudulent transfer and seize the asset. Yet another issue comes up. If in the division of assets, the property settlement, one spouse, for example, may get money, the other spouse gets the house. So the money might be what's referred to as equalization payments, so that the division of the assets is reasonably equal. Well, that income then is something that goes into determining eligibility, for example, for Chapter 7, determining how much is available to make plan payments in a Chapter 13 or a Chapter 11. So that is money that does play a role if you're receiving equalization payments and you want to do a bankruptcy. On top of that, if you've got this big pile of money coming in after a property settlement, that may be very difficult to exempt. And so if you file, let's say, a Chapter 7, that money is twisting in the wind, that Chapter 7 trustee is going to be very eager to grab it. If it's in a Chapter 13 or a Chapter 11, it's going to go into determining how much you have to repay over the life of the plan. Yet another thing that comes up. In order to understand this, we need to get a little vocabulary here. When somebody files a bankruptcy petition, the act of filing the petition creates a bankruptcy estate. What goes into that estate? Anything the debtor owns or has an interest in on the day the petition is filed. So that includes the home, cars, money in the bank, all the things that the person has. It also includes anything that the debtor becomes entitled to receive during the subsequent 180 days as a result of life insurance, inheritance, a marital settlement agreement, a devise, that kind of thing. The marital settlement agreement then includes the transfer of assets from one spouse to the other. If a spouse becomes entitled to receive something in that marital settlement agreement during the 180 days after the petition is filed, unless we can exempt it using the appropriate exemption table in a Chapter 7, that Chapter 7 trustee is going to be allowed to seize and liquidate it. And if you're doing a Chapter 13, the Chapter 13 trustee is going to say, well, you know, you've just been, you've come into some valuable asset, perhaps it's money, and you're going to need to devote that money to Chapter 13 plan payments. So yes, it can very much be affected by a bankruptcy filing. That is a property settlement agreement.